What's up, guys? Brian Fellow Law Group PLLC here with your Florida Law Weekly Case Update. I hope everybody had a great time in Orlando. If you went to the Family Law Conference this past weekend, I know I did, so good to see some people up there. First case, I got three for you this week, and some of these were actually discussed at the conference. First case is Dove versus Freer. I thought this one was interesting for a few reasons. First of all, as they pointed out at the conference, the trial court here found that the wife successfully rebutted the presumption against alimony. I never knew there was one, a presumption against alimony. That's certainly not in the statute, so I don't know where the court was getting that from. The other thing that was interesting, they reversed the alimony award, which was apparently too small, based on a Scrivener's error in the former husband's affidavit, his financial affidavit. So the trial court found that the former husband had a lower monthly surplus than he actually did because of a mathematical error. And the interesting thing is they weren't really looking at the husband's net income as defined by the child support guidelines. They were looking more at his actual surplus to determine his need. They were looking at his surplus on his financial affidavit after deducting all of his expenses. So interesting little dichotomy there where to apply the alimony guidelines, you use the net income pursuant to 6130, the child support statute. That's how you define net income. But for ability to pay, apparently, and this is in the fourth DCA, you still use actual net income, which apparently you can rely on the husband's financial affidavit, income minus all of his expenses to determine his ability to pay. Another issue in that case was the date of identification of a marital liability, classifying. And we all know you have to identify and classify whether a liability is a marital or non-marital liability based on the date of filing. That's the cutoff, right? And so here the court said that a marital liability was not a marital liability because it was after the parties separated. But remember, that's not the date for cutting off and identifying marital versus non-marital. But interesting point there where if you're a spouse that's leaving, that's separating, and you're leaving your spouse, but you're not getting divorced yet, theoretically you could run up a bunch of credit card debt, and it would still be technically a marital liability. Now there may be some arguments for dissipation or an unequal distribution, but it still would be a marital liability. Last part about this case was identifying and distributing the husband's sick leave. Essentially, he had extra sick leave from his employment, and you got to remember to include that as an asset. There's a lot of times you do these cases and you forget about those little things: accrued sick leave, accrued benefits from employment. Got to remember that if it was incurred during the marriage, that could be considered a marital asset. Next case is out of the third DCA, Paniry versus Paniry. It has to do with when you're challenging a marital settlement agreement based on fraud. To me, the court here kind of did like a two-part inquiry. So first, you have to determine, does the actual motion to set aside the marital settlement agreement based on fraud, does it have a colorable claim for relief? Is it facially prima facie case to set it aside? So that's the first step. This is in order to get discovery, by the way. This is in order to get any discovery, financial discovery. It seems like the third DCA is saying, first you have to see, is there a prima facie case pursuant to the actual motion? Next, have a hearing to determine if the former wife or person challenging the agreement based on fraudulent financial affidavit, whether they have detrimentally relied on that fraudulent statement or representation. Because if it's something that they didn't actually rely on or it was immaterial, then it doesn't even matter. So it's like a first step: does the motion have a sufficient cause of action, facially valid? If so, have another hearing. Step two, have a hearing to see a detrimental reliance, and then you can get your financial discovery. So important to keep that in mind if you're challenging or defending against that. Next and last case is Jackowska versus Blessitt. This is out of the second DCA. It has to do with fees, and this is a good one for the general standards, right? So when you're trying to get fees, let's say you put in all your billing records. You've satisfied your burden, right, to show this is the amount that I think is reasonable. Obviously, you have to have good billing records and have a number of hours spent, your hourly rate. Once you put that into evidence, the burden now shifts to the other side to sort of carve out any entries that they think should not be compensable because it's block billing or secretarial or things like that. So the trial court can't really just rely on argument from counsel or something, like, or can just the trial court has to base any reduction on actual things that are pointed out by the other side, carve outs, I like to call them carve outs to the billing. And they have to have like specific findings, like these specific entries I'm carving out because of this, right? Can't just be like a general reduction based on argument from defense counsel or from the other side's counsel. And then the other thing is, if the court is going to reduce based on a sanction or because the fees were not necessary, you have to actually, the other side has to really show and have the court make findings as to why did the additional litigation, how did that cause additional fees? And only the portion that caused the additional fees can be carved out and reduced. It can't just be like a general reduction because they litigated unnecessarily, right? I'm going to reduce it just because they litigated unnecessarily. No, you have to show how did their unnecessary litigation cause the reduction in fees? What was the actual unnecessary litigation, and carve out only specifically those specific entries. So, all right, guys, that's it. That's it for this week. I hope everybody has a wonderful week, and I'll see you next time. Take care.